Good afternoon. It's good to have Andrew Riley here again to talk about the ITC. Last time we talked about an overview of the process and why a company might use the ITC. Today we're going to talk about a unique part of that dispute, the domestic industry requirement. And generally speaking, it requires that a company invest a certain amount of their resources in the United States, but that is too broad to accurately capture it. That's why Andrew's here. He's going to tell us more about it. So please tell us, what does this domestic industry requirement mean?
Sure. So it's important to keep in mind that the International Trade Commission is a trade forum. And the idea here is that a patent owner needs to have something more than just ownership of a US patent in order to take advantage, basically, of the International Trade Commission, the ITC. So you have to have invested some amount of money here in the United States that's related to that patent in order to have the ITC at the end of the investigation issue a trade remedy against the accused infringers. So the patent owner has to show an investment in the United States. It can fall into one of three categories: plant and equipment, labor or capital. That's the second box. And then the third bucket or box would be research and development, engineering, or licensing. And those are the broad categories that the money has to be spent in. And it can be in one of those categories to satisfy the requirement. It does not have to be in all of those categories. And in some circumstances, money that you might spend on research and development could also count towards, for example, employment, because you're going to employ, if you have research and development engineers or scientists, you could also count their salaries into the employment box. But ultimately, the ITC looks at this sort of in two parts. They have an economic side of the domestic industry, and then they have the technical side of the domestic industry. And as a patent owner, you have to prove both of those things. The technical side generally can be very straightforward. Does your own product or a licensee's product practice the patent that you're asserting? Does it infringe your own patent, in other words? That's what needs to be protected. Again, this is a trade forum. The economic side is that investment that I mentioned. You have to spend the money here in the United States. And the easiest way to do that is if you make the product that practices your patent here in the United States, or you make essential components of it, you assemble it. Those kinds of activities here could potentially be enough to satisfy the domestic industry requirement. Now, why is this ultimately important? You can't succeed if you don't prove the domestic industry, and you have to prove both the technical prong as well as the economic prong. And so from a patent owner's perspective, you need to look at that up front and be prepared to come to the ITC with your evidence for the domestic industry, both the technical and the economic side of it. And then if you're an accused infringer, if you're the respondent in an ITC investigation, it's another point that you can put pressure on the other side for. If you can defeat either the technical prong or the economic prong, the patent owner will not succeed. And that's to your advantage. It gives you another place to apply pressure, not just arguing that you don't infringe and not just arguing that the patent is invalid.
Thank you, Andrew. And would it be fair to say that this requirement has gotten more attention in litigation before the ITC than perhaps it did a few years ago?
I've been doing this for, sadly, a number of years. When I first started, it was very easy for a patent owner to satisfy the domestic industry requirement, particularly under the licensing element. It's gotten much harder, and there's a variety of reasons for that. But I would say the last 10 years, there's been increasing scrutiny that the ITC itself pays to the domestic industry requirement, even going so far as to create a program that they call the 100-day program, where for certain cases that they evaluate that might be a weak point, they may identify that issue, the domestic industry issue, as being an issue that they want the judge and the parties to litigate within the first 100 days of an investigation, because it can be dispositive. Ultimately, if you don't prove that economic prong of the domestic industry or the technical prong of the domestic industry right up front, then the case should not continue forward. And so for certain cases, they put it into that accelerated program. It's a very small number, but they can't do that. And so that program, along with other activities, have shown over the last 10 years for sure an increased scrutiny. And it's not just from the International Trade Commission. The higher level review from the Federal Circuit, the Court of Appeals for the Federal Circuit, they've increased the scrutiny that they apply to decisions coming out of the ITC for the domestic industry requirement. Again, this is a trade forum, not just a court for settling patent disputes. You have to prove that there's a trade-related issue here, and that is, the importation of a good, and that they need to protect potentially a domestic industry here in the United States that's related to the patent.
Thanks, Andrew. So the takeaway here is look at this carefully. The courts are looking at it carefully. It's a unique requirement. So thanks again for your time. You mentioned damages briefly. We're going to do that soon, have a presentation on not damages, remedies, because there are no damages at the ITC. And we'll do that real soon. Thanks for speaking with us, Andrew.
Thanks, Jeff.